Any scientist, no matter how inexperienced, is aware of that fact. You cannot do an effective comparison between a known standard and an evidence standard without that size of sample.
So you're asking for 100 hairs?
We're asking for as many hairs as the criminalist or expert determines is necessary to effectively compare the standard hairs from the head of the defendant with the hairs found at the crime scene. And I've never seen a court attempt to restrict that, because that is obviously a matter that a criminalist would have to determine based on what he can recover.
Mr. Shapiro?
Your Honor, according to Dr. Henry Lee, our chief criminalist, who is the head of the Department of Criminology in Connecticut, he tells us 1 to 3 hairs are sufficient. I think perhaps this may be an appropriate matter for the court to have a hearing on. I think 100 hairs is unduly invasive. Makes the inventorying of the hairs a very, very difficult task, and certainly allows for the possibility of the commingling of samples, which could contaminate any test. So we would ask for a hearing on this. I've been practicing for a long time. I have never, ever heard of such a request.
Right. This is what I'm prepared to do at this point in time, and that is to order no more than 10 hairs at this point. If the prosecution at some point feels that they are in need of more hairs than the 10 that I'm going to allow at this point, then we will have that hearing with experts if necessary. This is not a matter that the court has independent expert knowledge concerning. So that's going to be the order at this point in time, subject to a further hearing with evidence, if necessary, from both sides for anything beyond 10 hairs.
Your Honor, I don't think that counsel has conferred with Mr. Lee concerning the nature of the test involved. If Mr. Lee is, and if Mr. Lee has informed counsel that only 1 to 3 hairs are needed for microscopic comparison, then he has misinformed counsel, and I can state that categorically. I'm very surprised to hear Mr. Shapiro has never heard of the number of hairs I have just indicated to the court being required before, because that is a standard thing. When a microscopic analysis is endeavored, it is required that you have standards from every area of the head, 10 hairs per area. That's a standard. I'm not talking about anything unusual here. Right, and what Mr. Lee is talking about, Your Honor, is PCR work. That's a whole different thing. We're not talking about comparison only for PCR. We're talking about comparison for microscopic as well.
All right. This is what I indicated I was willing to do at this point. You're of the opinion, and it may indeed be the correct conclusion, that you're going to need more than that. And the bottom line is that if, in fact, you do need more than that, you are going to have to produce an expert to justify that to the court. And if indeed that justification is made, I will sign an appropriate order.
Thank you, Your Honor. We will present that testimony today.
Today?
Yes.
Very well.
Thank you very much.
Okay. Now, yes.
On the matter before you do that issue, we do not have an indication as to how many follicles or shafts were found that the people are doing this for a point of comparison. And we asked the court to make such an inquiry so we would have knowledge of that.
Yes. Ms. Clark, do you know the answer to that question at this point?
I was told just this morning, and I not recall. I'm not going to make representation. We have an expert here who can tell the court precisely how many follicles and how many shafts there are.
All right.
I'd rather let them say.
Now, you indicate you do have an expert here. Do you want to proceed on this issue of the number of hairs right now, or would you prefer to do that sometime later? What is your preference?
Well, Your Honor, as I understand it, the court had required us to proceed this morning on the issue of the blood split that was requested. So the expert who is going to testify to that matter can also address the matter of the hairs, because she's the director of the crime lab for the Los Angeles Police Department. So we can do it all at once.
All right, that would be fine. Mr. Shapiro, I assume that you're prepared on the hair issue?
Yes, I am.
Thank you. All right. Then let's also, then in conjunction with the determination of the number of hairs, there remains the determination of the sufficiency of certain blood samples for defense splits. Now, I also should mention that the court is in receipt of the defense motion that was filed to quash and traverse and to suppress certain evidence. And attached as an exhibit to the defense motion was a property report listing certain items of evidence, I think 1 through 34 are denoted there. Is it correct that all of the scientific evidence about which that we're speaking about splitting is included in those items 1 through 34?
I don't believe so, Your Honor. I believe there is scientific evidence related to items recovered at the scene of the homicide, the 75 India. The motion only goes to the evidence that was obtained at the home of Mr. Simpson.
All right. Does anyone have something to provide to the court with a listing of what specific items we're dealing with if there's going to be different testimony concerning a particular item that was received in evidence, and the court would ultimately be making orders perhaps differing or designating certain samples that would be split and certain samples that would not be split? It would certainly be helpful to the court to have some sort of a number, and the way it's denoted in the property report would make sense, since that's the way all of you will be dealing with the evidence and the criminalists as well. Is there... All right, then I guess then we'll just commence with the testimony with regard to the splitting of the evidence at this point in time. Ms. Clark.
Thank you, Your Honor. The people will call Michelle Kessler.
Please face the clerk and raise your right hand.
I do. Michelle Kessler, M-I-C-H-E-L-E, K-E-S-T-L-E-R.
Thank you very much. You may inquire.
Good morning, Ms. Kessler.
Morning.
Please tell us what you do for a living.
I'm employed by the City of Los Angeles Police Department, and I am the Assistant Laboratory Director for the Criminalistics Laboratory.
Tell us what that means. What are your duties?
My duties include the managing and overseeing of several areas there, including the serology DNA lab, the trace unit, and many of the other units there.
And what does that mean? What exactly do you mean by that?
Well, in managing, it also means evaluating and implementing programs such as serology and DNA, and including evaluating crime scenes and managing task forces or large cases and the employees that are doing the work.
So you direct the criminalists in what to do, basically.
That's correct.
Were you once a criminalist yourself?
Yes, I was.
Tell us what a criminalist is.
A criminalist is one who collects, preserves, and analyzes all types of physical evidence and testifies in court.
Now, does that mean it's somebody that goes out to a crime scene to collect evidence from the scene?
Yes,
Of a scientific or evidentiary nature?
that's correct.
Have you also performed trace evidence analysis or blood analysis? Tests are available and appropriate to be performed on various types of evidence.
One of the things that a forensic expert must look at in any type of physical evidence, first thing you do is you look at the evidence, you find out, evaluate what you have, what it is, and then you proceed from there. And the type of testing you would like to do is going to again, best knowledge as to what they are.
I've never, ever heard of such a request.
Right. This is what I'm prepared to do at this point in time.
Hairs taken from different parts of the head.
All right, we're once again on the record, a case of People versus Simpson. The defendant is present with counsel. The people are represented. Mr. Shapiro, I assume that you do now have a copy of the curriculum vitae?
Your Honor, what I have is not the curriculum vitae, but a statement of qualifications.
All right. That's all we have. And Ms. Kessler, if you retake the witness stand. You've previously been sworn and remain under oath?
Yes, Your Honor.
Mr. Shapiro.
Good morning.
Morning.
Is it Miss or Mrs. Kessler?
Mrs. or
And-
Ms., whichever you prefer.
What do you prefer?
Doesn't matter.
Ms. Kessler, does your husband work for Los Angeles Police Department as a detective?
Yes, he does.
You know, I think it goes to credibility. I can make an offer of proof if you would like.
The objection is sustained. The motion to strike is granted.
Your Honor, may I inquire as to whether or not he is or has been assigned to the very division that's investigating this case? Would that be of relevance to the court?
You can ask that.
Thank you. What is your,
Overruled.
has your husband been assigned to the robbery homicide division, to your knowledge?
Yes, he has.
Is he still assigned?
Yes, he is.
And do you personally know the two lead detectives in this case?
I've worked with them for several years.
Do you know them personally outside of work?
No,
Have you discussed this case with them?
just as pertains to the case and evidence involved in the case.
And have you discussed this case with your husband?
Not really, no.
You have provided us with a statement of qualifications consisting of 3 pages in the form really of check boxes. Is this what you consider your curriculum vitae?
This is the only thing that we have used most recent years since Prop 115. This is all I have available at this time. This is what we've been considering our CV, yes.
My question is, do you consider this your curriculum vitae?
I have used this type of statement for years. I used to spell it out in terminology rather than have check boxes, and just, it used to look more narrative, but it didn't go into much greater detail.
Prior to being employed by the Los Angeles Police Department, what was your work experience?
I worked for approximately 5 years in a private laboratory performing chemical analysis and biological analyses.
What part of that work consisted of DNA?
DNA wasn't being done until the last few years.
What part of that work concerned microscopic comparison of hair?
None then.
What part of that work consisted of serology?
None at that time, other than in my master's thesis.
What part of that work consisted of maintaining samples of blood?
None.
What part of that work consisted of collecting samples of blood?
None.
What part of that work consisted of preserving samples of blood?
None.
Now, you have authored one article, is that correct?
I authored one article, yes. I've been co-author on several others that aren't listed here.
And what is the article that you have authored?
It was, I have to read the actual title. The lab goes to the lab,
When was that published?
1982,
And you were the co-author on that.
yes.
Have you authored any articles?
No,
What did that article deal with?
that is about clandestine laboratories,
Drug cases?
yes.
Had nothing to do with serology?
No,
Have you published or co-authored any articles on serology?
no,
Have you published or co-authored any articles on hair analysis?
no.
You indicate your training in the discipline of hair. Is that how you refer to it, the discipline of hair?
Actually, it's hair is just like a fiber, so I guess it'd be hair and fiber analysis.
Let me refer you to page 3 of your statement of qualifications, Mrs. Kessler. You list there courtroom experience, discipline, hair, 1980 through 1986. Is that correct?
That's correct. That's the last time I testified on a hair case.
And up until that point in time, you testified approximately 35 times?
That's correct.
I don't see anything on your statement of qualifications indicating testifying regarding blood samples, or blood preservation. Is your qualification statement incomplete in that regard?
No, it's under crime scene investigation and preservation of evidence on page 2. I've testified approximately 55 times in crime scene investigation and preservation of evidence, and in each of those cases, or almost all of those, has to do with blood preservation and obtaining sufficient sample for analysis purposes.
When was the last time you testified in a court of law regarding the amount of a sample necessary for preservation for later analysis?
Oh, let's see, probably about when did I prepare this? Actually, the date changes automatically, so the last time I testified, and that was probably about 1988, 86.
Do you recall which it was, 88 or 86?
No, I don't recall. I really don't recall the year, so sometime between 1982 and now, but only once or twice since then, because I've been in management most of that time.
And how many times have you testified since 1976 regarding the amount of blood that is necessary to preserve a sample for later analysis?
Between 30 and 55 times. Almost all those cases listed on page 2 that refer to crime scene investigation and preservation of evidence are dealing with blood.
And you were specifically asked the amount of blood necessary to be preserved for later analysis? Is that your testimony?
I'm not sure if that was exactly what was questioned, no.
In fact, that was never asked of you before today. Isn't that the case?
No, that's not true.
Do you recall when the last time you testified to the amount of blood necessary for splitting was?
I don't believe I've ever been asked to testify to that.
Now, I notice in your statement of qualifications that you indeed attended a seminar on DNA. Is that correct?
Yes,
And that was in January of 1988?
that was one, yes.
And that's 8 hours?
That's one, yes. I've attended several which are not on here. As I said, I was not prepared for this, so this is not up to date.
Well, it's dated the 24th, is it not,
I was
of
just-
this month?
As I explained, the computer automatically updates it, and I did not have time to go back in. There was apparently a rush to get this here, so.
Well, isn't that something that's standard for people who testify as expert witnesses to have a curriculum vitae that is current to date?
It's only required if I'm going to bring it to court, and as I stated, I don't testify much anymore, so I don't update this on a routine basis now. I keep track of my interests and what I'm doing, but I don't update the CV all the time.
When were you notified that you were going to come to court as a witness in this case?
Yesterday, or perhaps the day before, late at night.
When were you given information regarding this case?
Objection vague.
When were you given evidence regarding this case?
Well, I was never given evidence.
When were you aware that evidence was available during this case?
When the
That's
case,
irrelevant.
Oh, you can answer that.
whenever the case went down, there was evidence, but again, I did not expect to be involved. Cell-marked life codes. I have attended all the American Academy meetings for since 1985, which is once a year for 40 hours a week, and I would say at least 2 days of that is always devoted to DNA. I also have attended all the ASCLD Board of Directors meetings twice a year for since 1985 also, and there's always an update by the FBI and private laboratories on DNA analysis and what is required for that. And I have been instrumental in implementation of DNA in our laboratory as the manager, and so I'm very familiar with it.
Do you know who the scientist is that is responsible for the DNA subtypes that are being used in this case?
The scientist that's
Yes.
responsible, the person that developed it
Yes.
individually?
Yes.
Not off the top of my head. I'd have to look that up.
I take it you haven't read any of the books that he's published on this subject?
No, I have not read extensive books on the subject.
And I take it that you haven't taken any courses that directly relate to DNA in a school atmosphere?
except in college, and it wasn't, DNA was, barely mentioned as part of genetics and microbiology.
And when was that? I don't want to have to set a
That's
specific
quite all
date.
right, counsel. I'm not concerned about my age here. It was probably 1970.
And that was the last time you were involved in any academic setting?
Academic setting, that's correct.
Now, I understand that you list as your training the following things. How to turn your work group into a winning team, Los Angeles Police Department.
That's management training.
Okay, that has nothing to do with winning or losing a criminal case.
Not that I recall.
And then you've had 2 courses in management seminar.
Actually, that's an ongoing management seminar, as I stated earlier. As a member of the American Society of Crime Laboratory Directors, Board of Directors, I attend management seminars at the FBI twice a year.
And you attend seminars regarding sexual harassment.
I've attended. There's always an update on that, believe me.
And you've gone to forensic alcohol supervisor school.
That's correct.
Do you consider yourself an expert in DNA?
Not in DNA. I consider myself an expert in preservation, collection, and evaluation of evidence for all types of tests.
Do you consider yourself an expert in serology?
No, not in today's current serology. Again, evaluation, and I understand it. I can review reports and I can review people's analysis. I would never try to do it at the bench, but I do understand it.
Do you consider yourself an expert in the comparison of hair?
Yes, I do.
And what scientific training have you had academically regarding the comparison of hair?
Well, there isn't really any academic training other than my master's program, in which part of the courses in criminalistics involve comparison of hair. And also the Macron School, Hairs and Fibers, that's one of the academic courses, and I've been trained on-the-job training in the FBI method of hairs and fibers analysis.
Are you familiar with a gentleman by the name of Dr. Henry Lee?
Yes, I am.
And can you tell us who he is?
He is a forensic scientist out of Connecticut.
Do you have an opinion regarding his qualifications in this field?
Not in hair examination, I have no idea.
What about as a forensic scientist?
I don't know if Henry actually does any bench work anymore, or if he's like myself and he advises and oversees and reviews work and evaluates evidence. Other than that, I know he's like myself. He used to do a lot of bench work, and I considered at that time what he was doing as well as what I was doing, him to be an expert. He is also a member of all the associations that I'm a member of.
Is he a member of any organizations that you're not a member of?
I don't know.
Have you seen his 50-page curriculum vitae recently?
Objection, Your Honor. Counsel's testifying as hearsay. We have no evidence of that. If counsel wants to put it into evidence and call Dr. Lee, that'd be fine, but...
The objection is sustained.
If Dr. Lee is of the opinion that you only need 1 hair for DNA testing, would you agree or disagree with that, yes or no?
Objection irrelevant.
Sustained.
I'd like to now, Your Honor, direct the court's attention and the prosecutor's attention to the list of evidence, and I would like to, painstakingly as it may be, go through each item to see what tests were done, what tests are anticipated, and what the amount of sample is and how much remains.
Objection irrelevant.
I don't think it's irrelevant. However, do you have that information at your fingertips?
I'm sorry, could you repeat what you...
You testified there are 60 items of evidence. I'd like to first direct your attention to the items of evidence that relate to blood. And I would like to review with you each one of those items of evidence. What tests have been performed at your laboratory to date, and what tests you anticipate performing in the future, so the judge can make a determination as to whether or not we will be able to perform the exact same test. What we would like, Your Honor, is this. If they have done serology and DNA, and there still remains a sample, we would like to do serology and DNA.
No, I think I understand where you're going with this. You want to know how much of a sample remains.
Exactly.
And what tests have been done, and if no tests have been done, you want to know that also.
Correct.
Okay.
Your Honor, I think that perhaps it would be a lot more efficient if counsel would simply look at the documents he was given today, which indicate exactly what tests have been done and not done, and with respect to having the court determine whether or not further testing should be done, or whether sufficient volume exists to provide a split at this point in time as to any piece of evidence, how could the court do that? That's a matter for expert opinion.
Well, that's correct. And my understanding is the defense apparently intends to present some expert testimony on that issue.
Well, that was not my understanding, and I expressly asked Mr. Yeoman last night when he called to ask me what the order of witnesses would be. I asked him what witnesses he intended to call today, and he informed me there were none.
Mr. Shapiro?
Your Honor, I think we will be able to satisfy the court from this witness through our cross-examination that the tests that have been done, samples remain, and those samples will be enough for us to duplicate those tests in almost every area.
All right. Well,
In other words, counsel is indicating that he is not going to call any witnesses, expert or otherwise, pertaining to this blood split issue.
that seems to be the general import of what you're saying. Is that correct?
Your Honor, that is a general import. Obviously, we have the right to call witnesses. We do not anticipate calling witnesses, but as the court well knows, depending on the answers that are given, we will make that determination at an appropriate time.
All right.
Counsel is in possession of the information he is seeking in the list that was provided to him this morning. It indicates what tests have been performed. If counsel needs to inquire further as to what tests are planned, that could be done collectively as opposed to item by item.
Well, I'm not going to tell counsel that he has to examine in a collective fashion. You know, you can go item by item. If you have this particular information, it might be helpful if the witness has it also to refer to it, because there's so many items by number. I don't want to get into the results, however, of any of these tests.
I will not ask the results, and that is not my intention, Your Honor.
All right. You may
Thank
proceed.
you. Let's, may I direct your attention to item number 1? And just let me know when you have an opportunity to focus on that.
I'm fine.
Item number 1 contains 2 bindles,
No, it contains 2 swatches.
2 swatches. Okay, one
I'm
each.
sorry, item 1 is 1 bindle containing 2 swatches, and item 1C is a swatch, which is just a control sample.
So you would say that that item number 1 has 2 bindles that are composed of a swatch and a control.
No, I'd prefer to keep them separate because it'll just be confusing if we could stick to item 1 and then 1C separately. Item 1 contains 2 swatches.
And was any analysis done on item 1?
Not yet.
How much evidence is contained in item 1?
There is 1 swatch that's approximately 2 millimeters square and 1 swatch which is 1 millimeter square.
Where was that found?
Oh, yeah, I'm sorry, I thought we were going to deal with just quantity of evidence, not location.
Mr. Your Honor, counsel is in possession of a property report that indicates where all of these items were found.
I don't think it's necessary at this
Very
point in
well.
time to know where that
Thank
was
you.
located.
Thank you. When do you anticipate analyzing that?
Objection irrelevant. Counsel wants to know at this point what this witness's opinion is with respect to the availability of a blood split. When the test will be performed in the future is irrelevant to that determination. I think that counsel should be confining his questioning to matters that are now an issue. And that would be what tests have been performed, what tests are planned, and what volume she anticipates will be available for the blood split, if any.
I don't think that there's a problem asking about when a test is going to be performed, because that, I suppose, would be relevant in terms of knowing when there would be sufficient samples, since the witness has indicated that apparently she won't know until the tests are actually performed on any of these items whether there's going to be enough for a split. And we'll just be back here again doing this in the future to try to find out this information. If she knows when a test is scheduled at this point, she can tell us. If she doesn't know, then that's fine.
Well, my point is, Your Honor, it doesn't matter, because with respect to all of the items, the few items that she's indicated may be capable of providing a split, she won't have the answer for that either until the testing is done. So we're going to be back here anyway, because one way or
Well,
another.
I understand that. If within her knowledge, at her fingertips, here on the witness stand, she happens to know when a particular test is scheduled, and fine, she can answer that. If she doesn't, we're not going to go and research it anywhere. All right, Mr. Shapiro.
Yes, you may answer the question. If
We
you
have not
recall.
had a chance to get back to this at this time and schedule the testing. We spent a lot of time evaluating these samples, and that's about all we've had time to do.
When do you anticipate testing it?
Probably within the next, they'll be either sent out or be done in our laboratory within the next, as soon as it can be arranged, probably. It depends on our schedule. We have other courts, and so I'd say within the next 3-4 weeks.
What is the criteria for sending it out?
It depends on whether we believe that we can do it in-house. It depends what we're going to do on it. Obviously, if it's RFLP that we think can be done, it's going to have to be sent out. We don't do that in-house.
Is that the only thing that you would send it out for?
No, not necessarily. We also, if we're going to send it for RFLP, it's a good chance that we may decide to send all of it out for PCR, and that determination hasn't been made yet. Conventional serology, if it's possible, would be done in-house.
What test do you anticipate doing on this sample?
On this sample, it appears that, based on the small size, that we would be best suited to just attempt PCR and possibly limited conventional. But we'll try as much as possible. It doesn't appear to be enough for RFLP.
Limited conventional refers to what?
Limited means we will pick the best markers out of conventional serology, whatever they may be, the most discriminating markers, and just do those. We probably cannot do a full battery of conventional serology tests.
After the serology test is done, how much of that sample will be consumed?
Probably most of it will be consumed.
Then
It'll
we'll-
be extracted. The extract will still remain, but the sample as is, the claw squares will be consumed.
Part of the sample will remain, however.
The extract, which means someone has already worked on it and developed an extract.
Will any of the original sample be maintained?
No, can't.
So after serology, you are left with just an extract.
That's correct.
How much of the extract will be left?
I have no idea.
What do you anticipate based on the
It's
size?
not a volume at that point, because it depends on the concentration of the sample, and you can concentrate that down into essentially nil. So it's a concentration more than it is a volume. The volume is sort of irrelevant. It's more concentration of sample than volume. I can dilute it up and give you a gallon of extract, which means nothing,
Would there,
because it'd be so dilute you couldn't use it.
in your opinion, is there enough material here for both your laboratory to do a serology and for a sample to be given to independent laboratory for serology?
No,
So your opinion is there will be none left for any PCR test?
that's not what I said. I said there wouldn't be enough for us to do our work and someone else to take original sample from scratch and do any kind of serology testing, whether it's PCR, ABO, RFLP, etc.
Let me ask you regarding this PCR, that's a DNA test, is that
Yes, it
correct?
is.
And are there false positives in that?
Objection irrelevant.
Sustained. I don't want to get into the
you.
efficacy of various tests at this point.
Thank
Your
you.
Honor, may I
Let's-
ask if making a motion to the court?
Yes.
This is going to take hours in the manner in which counsel is proceeding. And I don't know that evidence is required to be taken in this manner. Counsel could sit down with his expert and talk to this expert, who would be delighted to share all of her findings with counsel and any expert counsel chooses to have with him, so that he can understand what her position is. And then we could frame a stipulation as to the nature of her testimony. This is going to take all day in the manner in which counsel is proceeding. And I don't think it's going to assist the court any in being able to determine its ruling.
Your Honor, with all due respect, I am representing a man who is charged with 2 counts of first-degree murder, where the people may be asking for the death penalty. And if it takes 2 hours to determine whether or not there'll be enough of a sample for an independent evaluation, where we believe samples can be contaminated, where false positives are possible, and where errors can take place in laboratory procedure, I don't think that's being excessive at all.
Your Honor, I take exception to the manner in which counsel has characterized my response. I am making a suggestion to council that would allow him to have much more information than he's going to obtain in the manner in which he's proceeding. If he wants the information so that he can make a determination as to how he wants to proceed with the evidence and what he wants to argue to the court, what I am suggesting would allow him to learn far more than he will in this manner. He needs an expert at his side so that he can understand what this witness is telling him, and the manner in which he's proceeding will not permit him to do so. So I am actually offering him the opportunity to learn a great deal more than he is at the current time. I'm trying to assist counsel in being more efficient and more effective.
We certainly appreciate that.
Mr. Shapiro, you know, I'm going to allow you to
It will not
present your motion your way.
Thank you. It's not going to be that time consuming. We've been here since 9:30, and so far I've been allowed to ask one question.
Well, I think you've asked a few more.
Well, on the direct evidence. There's 60 items, about 30 are blood, and I think the responses should take less than a minute. So if we don't have any further interruptions or suggestions as to how we should present our case, perhaps we can finish this.
Excuse me,
I don't think, excuse me, I don't think that's necessary from either one of you. So let's just proceed.
Thank you. The next item of blood that you have listed is item number 4. Is that correct?
Well, if you're referring to simply swatches containing red stains that appear to be blood, or that tested preliminary positive for blood, yes.
That's what we're referring to.
Okay, number 4.
That's item number 4?
Mm-hmm.
Would you describe item number 4, please?
It's one swatch that is 8 millimeters square. Approximately square. This is all an approximation on these measurements.
Have any tests been conducted on that to date?
No.
Do you anticipate any tests being conducted?
Yes.
When do you anticipate tests being conducted?
My answer on the testing would all be the same. If overall, maybe that would help. If
No,
we test-
I'd like to limit it just to this item,
Okay.
because this has a different quantity than the first, does it not?
Well, yes, but your battery of tests proceed in the same manner. And the extract on all of them has to be done first, and it's the same extract that's used for both PCR and RFP, so.
If you have no strenuous objection, if you could address item number 4 as a separate item, I think
Okay.
that would be helpful for us.
That's fine. I'm just trying to make it less confusing for everyone.
Thank you.
Could you repeat where we are?
Do you recall the question?
No, I do not.
Regarding item number 4, do you anticipate doing blood tests on this?
Yes.
What blood tests do you anticipate doing?
It appears to be enough to do, we hopefully to do both PCR, some conventional serology, and possibly RFLP, which would consume the sample.
If you just did serology, would there be enough of a sample left for an independent laboratory to conduct a serology test?
Well, serology, to me, includes DNA. So serology, DNA is part of all of it. Are you talking about conventional serology?
Let's get our terms correctly. Conventional serology is blood typing, is that correct?
Conventional serology is genetic markers, as is DNA, if you will. They're all genetic markers.
Let's start with the first test that you would anticipate doing and use your terms as to what test that would be.
I'm assuming, what I think we would do here first would be to attempt to do DNA, and then, if there's any remaining, do conventional serology.
If you did DNA first, do you anticipate, is there enough to do DNA?
Well, I indicated that RFLP, which is the most sample-consuming DNA, as opposed to PCR, which requires less sample, that we would consume the sample.
You haven't done RFLP on anything yet, have you?
No.
All right, so let's go with what you've done so far. So far, you've done serology on samples, and you've done PCR on samples, is that correct?
That's correct.
Do you anticipate doing serology on this sample, yes or no?
Only if there's sufficient sample.
Do you know as an expert witness whether or not the quantity you have is a sufficient sample for serology, yes or no?
As I indicated before, if we only did serology, yes, there's probably enough there to do only serology, but we would want to do RFLP first.
Would you just please answer my questions?
I'm confused.
Argumentative. The witness is attempting to answer his questions.
All right, ask your question again,
Thank
Mr.
you.
Shapiro.
Do you have enough of a sample to do standard serology, yes or no?
It appears we do.
If you did standard serology, would there be enough of a sample remaining for an independent laboratory to do serology?
Objection irrelevant. Your Honor, this is the point. We intend to perform serology, RFLP, PCR, polymarkers, every test available on each piece of evidence. And the only relevant question is whether after the completion of all of those tests, there will be sufficient evidence left for a split.
All right, the objection is sustained.
May I be heard on that, Your Honor?
Yes.
Based on the records we have received, the following tests have been done.
Have already been done?
Have been done by LAPD. Serology and a DNA test known as PCR. They have done no other test. And I've asked the witness this, and she has acknowledged that. What I would like to establish for the record is this. For those that have not been done yet, just go piece by piece. If you do serology, would there be enough for us to do serology? If you do PCR, would there be enough for us to do PCR? If you do other tests, would there be enough for us to do it? To make a record, because if these samples are consumed and we want to contest the fact that possibly exculpatory evidence existed, that we were deprived the opportunity of exploring, that should be part of the court record.
Your Honor, and it's irrelevant to our consideration. That is exactly the point. I don't think counsel understands. We have a battery of tests to which this evidence will be subjected. The question to be answered is whether or not after the tests are completed, they're sufficient for a split. That's the question, not whether after each test is completed, because counsel has no right to dictate to the prosecution the manner in which a case is investigated. We will subject the evidence to every test available and every test possible, and at the conclusion of those tests, if there is sufficient left for a split, we will be delighted to share it with counsel. We've made that clear. And this expert is only here to testify as to whether or not after the conclusion of all of the testing we deem appropriate, such amount will be left over. That's the only thing, not after each test. After each test makes no difference.
All right, Mr. Shapiro, I agree with the prosecution on this point because I'm not in a position, I'm not going to put myself in a position to say that they can or cannot perform a given test on a given sample. And I don't think that's what the court's position should be.
Your Honor, I want the record just to be clear that we are requesting samples of all material relating to blood that have not yet been tested for our own testing, and I will leave it at that.
Okay, and I think that record is clear.
Thank you very much, Your
Let me
Honor.
also make the record clear then, Your Honor, that I have repeatedly advised counsel that I am going to make every single test ready for observation to him and to his expert. Every test performed can be observed in every step of the process by his experts at his choice. And if there's some question he has or concern about buffers or solutions being contaminated, we will be delighted to provide a split of any buffer or solution that is being used in the conducting of any test. So counsel is going to be allowed to examine every piece of evidence, observe the testing process to make sure that evidence is appropriately handled. And I want to reiterate that invitation on the record once again.
All right, and I think the record is clear on that also.
Thank you very much, Your Honor. The next item that blood was found is item number 5, is that correct?
That's correct.
And would you, have you done tests on that item or not?
No.
Next item where blood was found is item number 6, is that correct?
That's correct.
Have you done testing on that?
No.
The next item where blood was found is item number 9, is that correct?
No, I believe number 7.
Number 7? Okay. Have tests been done on that?
No.
What about number 8?
No.
Was blood found in both of those?
Yes.
What's the next item where blood was found?
Number 9.
Has testing been done on that?
Yes.
What test? What was the first test that was done on item number 9?
The first test, because the sample appears to be very weak, was PCR.
Is there anything remaining of that sample?
The glove gives quite a bit of positive area for blood. You cannot see it, you cannot differentiate how much is there because of the leather. And until we actually extract it and work with it, we don't know. Yes, there's some remaining, we don't know how much.
Is that enough remaining, in your opinion, for an independent laboratory to conduct their own investigation?
Not to split it this time, no.
Is there enough remaining for an independent laboratory to conduct their investigation, yes or no?
Objection asked and answered.
It was asked, but it wasn't answered.
Do you know?
Well, I have to clarify this. If you mean, we're not done testing, so do you mean at this time or when we're done testing?
At this time.
At this,
Objection irrelevant.
Sustained.
What additional tests do you intend to do on this?
we're going to do everything possible, and again, until it's extracted, I believe we'll even try for DNA, RFLP DNA, but we're skeptical that there'll be sufficient there for that.
The next item I have, and correct me if I'm wrong, is item 17 where blood was found.
No, actually number 11.
11 and 12? You have not analyzed yet, is that correct?
No. I'm
Next
sorry, 11 we did not test, 12 we did.
12 you did test?
Yeah, I didn't hear you say, I almost thought you didn't say 12 because I thought we were going one at a time.
And on 12, what test did you perform?
PCR.
Is there any sample left on that?
Yes, there is, and we're not completed with our analysis yet.
Will there be any sample left, in your opinion, when you complete your analysis?
Objection irrelevant.
Well, you're referring to completing all analysis, is that correct, Mr. Shapiro? in your
Yes.
question? Overruled, you can answer that.
I believe I answered this earlier. I felt that there would be a possible sufficient amount when we're done, but we won't know until we're done.
The next item where blood was found is item 17.
Actually, number 14,
There was an analysis done,
yes, PCR.
and the sample has been depleted.
Yes, it has. It was very small.
Now you say an extract was saved.
Yes, we saved the extract.
What does
We
that
still have
mean?
That means the portion at which you're concerned about contamination, which is in the extraction process, or at least one of the processes involving DNA of PCR, we extract the sample. We still have what's left of the extract. You don't need all the extract, but
Is
you
that a-
have to extract the whole sample.
Is a portion of that available for us?
We're not done. We may try to do some more with that, including polymarker. We'll send the extract.
Do you anticipate a sample will be left for us?
Probably not, because again, it's a very, very weak, small stain.
The next item where blood was recovered.
Well, 17 is the reference blood.
Okay.
That wasn't found there. That's a reference known blood.
Next where blood was found at the scene. At one of the crime scenes.
Well, item 20.
What about item 18? Shoes, was any
Oh,
blood
no,
found?
no, there wasn't any. That's the test. We did a search for blood, didn't find any. I don't know if we're getting into that.
All right, the next item that you have,
20?
has that been tested yet?
No,
21,
not tested.
23,
22, not tested.
23,
23 PCR, plus the extract remains, and we intend to do the same with that as all others.
you don't, right now, does a sample exist?